I think I want to follow up a little bit more on the whole issue of conscience rights protection. And if you could, I think it's an issue that's important to a lot of folks right across Canada. It's an important issue to this committee, and we want to see if somehow we can address that. And I'd like your comments and feedback a little bit on what is possible from a legal perspective to draft something like that into the bill. What would it look like? Where would it belong? How can we do it?
Mr. Chair, thank you for the question. First, I would say, as the two ministers indicated, the government very much has acknowledged that the protection of conscience rights is an important consideration in moving forward with this. And also, the Supreme Court of Canada obviously acknowledged that there are among the various rights and interests to be balanced, the conscience rights of physicians and medical practitioners is an important consideration. As the two ministers indicated previously, nothing in the bill compels or in that sense coerces a medical practitioner to be involved in this. The government has announced, the Minister Philpott confirmed today, the intention to continue discussions with provinces and territories about a continuing care, and Mr. Kennedy and others can speak to this if you wish, a discussion about ways in which access to care can be facilitated. And information can be provided, and that will be one element of a discussion around the ways in which conscience rights can be protected. But although the Supreme Court has acknowledged that healthcare is a concurrent jurisdiction, this is an exercise of the criminal law power by the federal parliament that's under discussion. This is not a medical regulatory or regulatory of health professionals or health institutions bill. This is an exemption which is being created in the criminal law. And that's been the focus of the attention in response to the way that the case was framed in Carter and the way that the case has been brought before for Canadians, going back to the Rodriguez case. So in all of that, the consideration was what the focus of the bill is about. The way in which the bill is constructed is designed not to require or compel any medical practitioner, doctor or nurse practitioner, to be involved in this. And as Minister Philpott indicated previously, the government's commitment is to continue those discussions with provinces and territories to try to, I think the expression is to find pathways to care. So I hope that that's responds to the question.
Well, it responds, but it wasn't really the answer I was looking for. I was hoping to hear you say that, well, we should draft something into the legislation that would provide protection for healthcare individuals, that they're not coerced into doing it, and that there's a protection for them as well, because there's a fear among healthcare professionals that they're not going to have a choice, and not just at the physician level, but downwards from there as well. That individuals that are currently tremendous and wonderful individuals who are providing excellent health and palliative care are going to be forced to participate in a physician-assisted suicide procedure.
Thank you for the question. I fully understand, and we have observed the debate as it's unfolded and continues to unfold in provinces and territories with medical regulators, with physicians and others across the country. The bill does not compel or require anyone to provide the assistance. It opens an exemption in the criminal law to protect those who fit within who are providing medical assistance to individuals who fit within the criteria as established in the bill from what would otherwise be criminal liability. That's the nature and scope of the bill and the intention of the government. There are a variety of other regulatory medical professionalism and other issues associated with this. We know, as from our discussions on our side, and certainly from the Health Canada discussions with provinces and territories, we know that medical regulators, provinces and territories are actively engaged in looking at their dimensions of this issue, and we've no doubt that examination will continue.
Okay, I'm gonna keep on that though. I don't want to let it go just yet, because I think we could be preemptive. While we've got the debate going and while the discussion is open, I think we can be preemptive rather than leaving it to the territories and the provinces to come up with their own regulations and maybe create a problem for healthcare officials. Why don't we address that issue right now up front with the legislation that we're looking at?
I think in respect of the exercise of the criminal law power and defining the nature and scope of eligibility and safeguards the law is clear. I think the government's commitment to complementary and additional measures and discussions is also clear. And I think from the perspective of the way in which the law is constructed, it is constructed explicitly not to compel or require anyone to provide assistance in dying.
Thank you, Chair. On conscience protection, you've said that the bill does not compel or require. You've said that the Supreme Court said that we're to create a complex regulatory system. There has been a major focus, rightly so, on vulnerable Canadians, but on conscience protection is probably the #1 issue that we hear from as parliamentarians. Make sure that the conscience are being protected. So it's silent. The legislation is silent on it, does not compel or require, but it also does not protect. It is possible then, as we amend the Criminal Code of Canada to permit this, we could also make it a criminal offence to coerce, intimidate, force a physician against their will to participate. Is that not correct?
I guess we would have to look at it. I'm not aware of the circumstances in which that is a concern. I guess we'd have to look at it. And I would say that in respect of the scope of federal jurisdiction under the criminal law, we would also be focusing on the extent to which provisions that are inserted would have practical legal effect given the division of powers. But
then the provincial regulators, you said, their examination will continue. But we're talking about exemptions to the Criminal Code of Canada that permit this under certain strict criteria. You cannot, before you, not even presently, it's legal to take your own life, but you cannot, a person walking down the street cannot assist somebody to kill themselves. That's illegal. We're creating this strict regime. But you should also then not force somebody by intimidation, coercion, or any way to participate into the death of that individual against that person's will. And so that could be included in the criminal code, is my understanding, and still then be with, otherwise we hand it over to provincial college of physicians, and it would not be a pan-Canadian, it could be a total different approach if we allow it to each province to protect the conscience rights. But we do, I believe, have that power, that authority to put that within the criminal code, that you cannot force anybody to participate in the death of another person, do assisted suicide against their will.
If it's the committee's wish in terms of the completion of the study, we can certainly look at that.
Thank you very much. We appreciate that. I mean, I think the conscious rights have been raised by a number of people. And I think that Mr. Fox's original question was trying to ask you, if conscience rights are important to the committee, what solution you propose to make it fall within the law in the best possible way. One way that was suggested by Ms. Khalid is making the criminal prohibition, and if there's others, we'd be delighted to hear before we move to our clause-by-clause deliberation.